Moving on, the Delhi High Court in a landmark verdict has said that the eldest female member of the Hindu Undivided family can be its Karta. Karta denotes managership of a joint family and is traditionally inherited by men. The verdict came on a suit filed by the eldest daughter of a North Delhi business family, seeking entitlement as the Karta on death of her father and three uncles. Now, how significant is this ruling? To get us more perspective on this ruling, joining me here on Magic Bricks Now is tax and legal expert Vinay Singh. Mr. Singh, thank you so much for joining us on Magic Bricks Now. First question to you, according to this order, now the eldest female member of a Hindu Undivided family can now head it. How significant is this ruling?
See, there is a background to this judgment in the sense that prior to 2005, it was always the male person who could be a male member of the family who could be a co-partner. Now, in 2005, a very significant amendment was made to the Hindu Succession Act, and namely Section 6 was introduced. And Section 6 said that basically it placed the girl child of a family on the same footing as the male child. So, the woman was entitled to be a co-parsoner. The rights in the property were identical to the male child in all manners. So, that itself was a very significant step. However, there was one little question that although the female child has been placed on the same footing in terms of inheritance of property, whether she has the right to administer the affairs or manage the affairs of the Hindu Undivided family was a bit of a grey area, where some people may argue that okay, she may have a right in the property, but she does not have the right to run the family as a Karta. Now, this judgment is a very good judgment and clarifies this very point that if she has the right in the property and the idea of the parliament was to place the female child on the same footing as the male child, then why can't she run the family affairs? So, it's in a sense it is logically following that amendment which was made in 2005. So, I think it's a wonderful thing and clarifies lots of things.
All right. Also, give us some perspective on this move. What does this move mean from the point of real estate, since women anyway have a right to share an ancestral property?
Yes, see, they will be co-owners. As a Karta, she will be the decision maker in this instant case vis-a-vis the other cousin who was a younger cousin who was challenging her. So, in effect, if you would have to end up dealing with her definitely. There is no other change as far as the ownership is concerned, but in terms of the management of the property itself, if the HUF has property, would all now vest with this one person, the female. So that's a good sign in itself.
Last question to you. Now, this is a landmark ruling from the Delhi High Court. Will this be valid across the country?
No, see, generally a High Court judgment applies only to that particular state, but it does have persuasive value. If tomorrow the same question is raised, say, in Maharashtra, then Mumbai High Court would also like to look at what other high courts have had to say. And if there's no fine area and there are no points of dispute, generally a high court would follow the logic also of another high court, though one cannot say definitely. But here I think it's fairly clear cut, so we don't see a problem there. It has a lot of persuasive value in other states, though it does not have a legal binding.
All right, Mr. Singh, thank you so much for joining us here on Magic Bricks Now.